Welcome to episode number 12 of Upstate and Litigate. I'm John DeGasperis.
And I'm Derek Spada. Today we're going to talk about slip and falls. But before we do, we're going to talk about recent victories. John, any recent victories, maybe in the area of slip and falls?
Happens to be that I just took a verdict in Montgomery County, the western part of New York, where I represented a woman, an elderly woman who slipped and fell on ice. That's not the topic of today's show. That was episode number 2. But she slipped and fell on ice. She lived in an apartment building that serviced only elderly people, and we filed a case against the landlord. It was our claim that the landlord, one, neglected to remove ice that had existed for several days before the date of accident. And in fact, we were able to establish through records that the landlord had not gone to the property since collecting rent at the first of the month. And also, our client claimed that when she slipped, she grabbed onto this railing, this makeshift railing that was created, and the railing failed because it wobbled. And she claimed that it had wobbled for 2 years since the day that she moved in. So we had a multi-dynamic claim against the landlord, which is always helpful. And the case went to trial. We tried the case for 3 days. The settlement offer was $70,000, and the jury verdict was just under $350,000. I thought it was a nice, fair verdict. It was a good trial. It was the first trial I ever had where my client appeared remotely. She was in Florida. She had moved to Florida so that her son could help take care of her. And she got sick right before trial, so the judge allowed her to appear remotely. The orthopedic surgeon had testified ahead of time, so we had him on video. So the trial in many ways was virtual, and the jury didn't seem to mind. They gave us a great verdict after 3 days. I was proud of the outcome and happy for the client.
Nice.
Yeah. How about you? What's been going on with you?
I have. In the area of slip and falls, I had a few motions that went my way, summary judgment motions where the defense tried to have a case dismissed.
Your specialty?
Yes, that's what I do. It seems that way. And I'll talk about the one, I'll call it an exotic case, if you will, which is doesn't quite fit the norm. But the client was hired by a local property management company that they run Airbnbs and clean homes for weekenders. And so what happened was the person who worked there before my client used the wrong kind of floor cleaner, and we're not even sure what it was. But the company gave this person some really slippery stuff to put on the floor.
These are tough cases.
And it's a tough case.
Yeah.
So
you had a good outcome, but these are tough.
The homeowners came home, for the weekend, and the floors were so slippery, like they could barely walk on them. So they called the company and asked them to send somebody back to get this stuff off the floors, to clean the floors again. And so the following week, the company sent someone back, which happened to be the person who became our client, and it was her first day on the job, and she thought she was an employee of the company when she was hired, but so then she went there, and of course she slipped and fell on the excessively slippery floors while doing her job. And so then she tried to file a workers' compensation claim, which is normally how it would have gone, and there would not have been any case. But the company said that, no, she's not our employee. She's an independent contractor. So they had no workers' compensation coverage for her, which then opens the door to suing the company. So in New York State, you can't sue your employer if you're injured on the job, unless your employer does not have workers' compensation coverage. Then you can sue the employer. Yeah. So that's what we did here. And so the employer tried to have the case dismissed. That ruling went in our favor. So the case is proceeding. I'm trying to get a settlement for the client here. I think it'll work out for her. It's a matter of time.
I handled a similar case, slip and fall due to excessively slippery floor from a cleaning substance. And I got a settlement. In that case, I represented a doctor who fell in a medical practice that she was covering at, which leads us to the topic of today's show, which is slip and falls, but not slip and falls that happen on ice, because we don't have ice here anymore in New York, so why talk about it? But that again, we did discuss in episode 2. If you're interested in learning about slip and falls that occur as a result of ice and how those cases are handled, go to episode 2. So, Derek, someone falls. Maybe they fall due to an uneven surface. Maybe they fall because there's a hole in the ground. Maybe they fall because a ladder or scaffold collapses. Maybe they fall because the floor is excessively slippery. or they slip in a slippery substance. They call the office, they're injured. What happens? What do we do?
Well, what we do is, first ask them if they know exactly what caused them to fall. That's the first hurdle that you have to get over, is knowing, did you fall because the floor was excessively slippery, or did you just trip over your own 2 feet, or something of that nature? So once you can identify the cause of the fall, then, of course, we ask if there's any photographs or any kind of evidence of the condition that caused the fall.
Photographs on falls are huge.
Yeah.
They're huge.
Yeah, especially, stuff that's not there permanently. For example, like water on a floor or some kind of spill on a floor, ice is going to melt and disappear.
Right.
If it's something like a broken sidewalk, that's probably not going to be fixed in a matter of a couple of days or weeks. But something that's
But they can get fixed. I've had that.
Yeah, they can.
Yeah.
They can. So so photos are always critical, but especially things that can and will change or disappear over time.
You know what I think is also a very important element of proof for falls? Reporting the accident. Some document created by another party
if you fall in a store,
verifies that you fell.
Yeah, if you fall in a store, you should always report it to a manager of the store.
Yes.
And ask them to fill out an incident report.
I would also say, if you fall outside of the store, go in and report it anyway.
Yeah.
Right?
Yeah.
And I think you and I see this a lot at your big box stores, like your Walmarts, right? Someone falls outside in the parking lot because of a pothole, because of some foreign object or ice, whatever it may be. And then they get in their car and they go directly to the hospital. And it's like, well, that's great. And that does help document the situation, believe it or not. We'll talk about that in a minute. But go in and report it.
Yeah.
Right?
Yeah.
Because it's important because, one, someone else is verifying that you fell, right? Someone else may come out and look at the thing that caused you to fall and say, I saw it, right? I went out and verified there was a hole in the sidewalk, whatever it may be. That is critical for juries and for insurance companies. They feel better about those claims versus falls where, the incident is like a ghost. Someone falls and then a year later, the property owner is notified for the first time of that fall. Those cases are hard.
Yeah, yeah. And if you fall at I'll call it a big box store, even a small box store, those stores rarely own the property that their store is located on. So if you fall out in the parking lot, if you go inside and report it to the store, they'll make an incident report that is generally favorable to you because they have no skin in the game, if you will. They're not going to be a potential defendant in the case.
You know what?
They're often helpful.
You are right that oftentimes the big box stores don't own the property where you fall, especially if you fall outside of the store. But recently, I've had some falls that occur in Walmart parking lots, and Walmart owns the parking lot.
Oh, yeah?
Yeah, 2 in a row, both in Western New York. So,
yeah.
I don't know, maybe there's just not enough commercial real estate investment firms buying property out there. So maybe Walmart does the development themselves. But I have 2 cases in Western New York where Walmart actually owns the parking lot. And that's kind of a weird phenomenon for them.
Yeah, that's pretty rare because the ones around here throughout the Hudson Valley, I don't think Walmart actually owns any property in the Hudson Valley.
And what's also interesting is, we all know that Walmart is rich, but in these cases, I'm learning that Walmart has a land trust because that's the deed holder happens to be a Walmart land trust.
Yeah.
So these people are making money hand over fist, and now they got a real estate trust. So good for Walmart, bad for consumers. But all right, so now a client calls, they suffered a fall. I agree with you. First instinct is, did you report it? Do you have pictures? Do you know what caused you to fall? Then we get into, are you hurt, right? Yeah.
Have you gone to a hospital or doctor? And if not, if you're actually injured, you should go like now.
Yeah.
And but if you are injured due to a fall, even if you think you're not that badly injured, you should still go to a hospital or urgent care or call your doctor as soon as possible to make an appointment.
Yeah.
Because things that seem, I'll say, relatively like a minor injury initially can progressively get worse over the following days or weeks. And then if you wait like a week or two and see if it gets better and it only gets worse, then you go to the hospital. Then later on down the road, the defense attorney or insurance adjuster will say, Well, nothing happened for 2 weeks. Your client didn't even go to the hospital or doctor or anybody for 2 weeks. They couldn't have been hurt that badly.
Right, right. And there's no doubt that the injury profiles that we see in our law office stemming from falls really run the gambit. And the best cases are certainly those where the client had no option but to go to the hospital because, they broke their leg and they couldn't even walk. Those are naturally your better cases. But you and I will handle even ankle sprain cases because it's the right thing to do. If someone slips or trips and falls and they sprain their wrist or sprain their ankle or get banged up, when an elderly person falls, even if they don't break a bone, that fall feels like they got hit by a truck, right? And so it's the right thing to do. We help them. They're not big cases for us in the grand scheme, but they're big cases for those individuals. And, they only get what's fair and just for the circumstances, but we will help them. But in those cases, I think that first visit to the hospital is even more important than those bigger injury profiles because those injury profiles are undeniable, right? If someone goes in with a comminuted displaced fracture of the femur, there's no doubt that person just took a bad fall, right? And that was my case up in Montgomery County. I mean, we had an X-ray where the leg is angulated. No one's walking around with that. No one's faking that thing, right? So, but when you sprain your back in a fall, that's harder to prove because the diagnostic studies, they're not going to be as obvious and not as easy for the jury to latch onto. That's why it's important to go and treat with a doctor, you were talking about this the other day. Go to an urgent care. Takes you an hour of your time. It's documented, and if you get better, then maybe you don't have a good case, but at least you went and documented the injury.
Yeah.
And I don't know about you, but in my falls during trial, some of the key pieces of evidence are the ambulance report, the ER record. Why? Because it's the client before the client has a lawyer, they're going to a medical professional and reporting, this is what just happened to me. And so it tends to help substantiate the claim. It verifies that here we are 2 years later, but this is what they said at the beginning before they were even thinking about a lawsuit or whatever it may be. So those early on medical records are clutch.
Yeah, and if there's a real dispute about what caused the person to fall, you could also subpoena the paramedics who came to the accident scene and ask them what they saw.
Yeah, and also witnesses, right? I mean, I can't stand this exchange with clients. Okay, were there witnesses?
They say, lots of witnesses.
Lots of witnesses. Oh, good. Okay, what are their names? Oh, I don't know anybody's names. What do you mean? You just said there's a lot of witnesses. Oh, well, I don't know anyone, but there were a lot of people who saw it. That's frustrating.
Yeah.
And listen, I understand when you're seriously injured, you're not thinking about witnesses, but your family members could. Right? Or when things calm down a little bit and you're feeling a little bit better, or you're waiting for something to happen in the hospital, just take a moment and think about who saw this, or how can I reach out to the witness? How can I get that person's contact information? Because just as Derek and I are saying here, reporting the accident is important because it verifies that it happened. So when you have a fall that has been witnessed, that case is much better in terms of quality. It's easier to prove.
What about a wet floor sign? Do you want a case where someone falls on a liquid on the floor and there's a wet floor sign there, or would you rather have no wet floor sign?
Well, listen, in my own social media, these are the videos that go viral, and it's contrary to what your instincts tell you, and I think you'll agree. I want the wet floor sign all day, every day.
Yeah, and the reason is that if there's a spill, the store owner has to do more than just put a wet floor sign out. They're supposed to actually clean it up and make it safe instead of just putting a warning sign like wet floor, and if you fall, well, too bad.
And I'll even say this. I think you're right? That's our opinion as lawyers who believe that business owners and commercial enterprises have a duty to keep their property safe, and that just putting out a sign without actually remediating the problem, that's our position. There may be times where the wet floor sign is enough, right? Maybe a jury will say, hey, listen, that property owner, under those circumstances, did what was reasonable. And so that property owner may be absolved of liability. But tell us really why. Why do we love the wet floor sign? Why do we love yellow, painted sidewalks? Let's get nerdy for a second. And this is right up your alley.
Well, the legal concept is called notice. So in every fall, you need to prove notice, which means that the property owner knew about this dangerous condition, or at least should have known about it, or otherwise that they did something to actually create the dangerous condition. So in most cases, if there's a spill, liquid or ice or whatever on the ground or floor, and a person falls on it, the property owner typically doesn't actually create that condition. So we have to prove that there was notice, meaning that whatever was on that floor that caused you to fall was there for an adequate period of time for the store owner or some employee to at least discover it and do something about it, such as tell people not to walk in that area, mop it up, or put down salt if it's ice, or do whatever they have to do to remedy this condition. And so the wet floor signs provide notice. That means that someone, store employee, knew about this condition and chose to just put out a wet floor sign as opposed to adequately cleaning up the mess.
Yeah.
It's the same, like, for example, like with a dog bite case. If there's a beware of dog sign at someone's house, again, that shows notice, meaning that they knew the dog was dangerous, so they put up a beware of dog sign.
Notice of the dangerous condition is elemental to virtually all negligence cases. I just settled a sexual abuse case against a local school district. I had to prove that the school district had notice that teacher was doing something inappropriate. And if the school district did not know, then it can't be held liable. And I think notice, especially as it relates to premises liability cases, but across the board, that's the fairness, right? We're not going to hold property owners accountable if they did not know that there was a problem. This is my classic example. When a client comes in and we're talking about the merit of their case, I say, listen, let's think about your local grocery store. If you walk into an aisle and someone happens to be reaching for a jug of milk and they spill it right as you're walking by and you slip in that milk, should the grocery store be held liable?
Well, I would say yes, but unfortunately the law says no.
Yeah, right. You would say yes, but the law would say no. Why? Because the grocery store didn't have any time. They didn't know that spill happened. It just happened sort of simultaneously with you were walking by. So the grocery store is not liable. Now let's do a different set of facts. Someone spills a carton of milk 5 minutes before you go into the aisle, and the store manager walks by, sees the milk, but needs to take a cigarette break. And so neglects to put out a wet floor sign, neglects to mop the milk, and then you slip and fall, right? Well, now the store had notice of the dangerous condition, neglected to address it, and you got hurt. Now it's fair to hold that store accountable. And that's my classic example, and I think people can connect with that. So notice is fairness. If they knew that there was a dangerous condition and neglected it, they should be held accountable. If they didn't know, typically they're absolved of liability.
And if you fall in a store on a spill, you should look for clues. I mean, granted, you're injured and laying there on the floor, but you should look for clues as to how long that spill was there or how that spill got to be there. So, for example, if there's a milk jug on the floor and you fall in the milk, it's hard to know, did that happen, 10 seconds before you came into the aisle, or has it been there for 2 hours? Right. But if you look at the spill, look at the surrounding area, you can see are there footprints through it. Other people walk through it,
shopping cart
tracks, things of that nature.
Is it dirty?
Right. Is it dirty? Is it starting to dry up? Like for example, if it's starting to evaporate, you can tell like around the edges, if the edges are starting to dry out. There's signs of this. So, granted you're on the floor there, injured, but at least take a look at it. Again, this goes back to photographs. Photographs are critical for things such as notice. Right. And, for example, I've had some falls in stores where the roof leaks. So again, it's a leaking roof.
Right.
And those are generally good cases on notice, because unless the roof happened to just start leaking that a few minutes before you actually fell.
Well, how about the time you and I litigated the case together with the woman who slipped and fell on ice? It's an ice case, but And remember, it was like, where did all that ice come from? There was a lot of ice. It was like 4 inches thick.
The gutter.
The gutter above where she fell broke. And it's like, okay, well, I don't know if I can prove notice. Do you remember how we proved notice? There was the garbage bin had been moved under the gutter. So the property owner didn't fix the problem, just put a garbage can under the leaking thing, and someone moved it, right? Or did it fill up? What was it?
I think it filled up with water and then overflowed. Yeah. And then
right. It was like a big block of ice in the garbage can. Yeah. So that's, and the case I just tried in Montgomery County, we argued that the property owner should have known about the ice because, and I said to the jury in my closing, I don't think he knew. There's no doubt about it. He should have known. A responsible landlord who rents only to senior citizens with the weather pattern that had come through in the week prior to the fall should have known. He just didn't care to know, right? And so you can't neglect your duty to know and then defend yourself by saying, hey, I didn't know. I didn't go to the property for 3 months. That doesn't work either. But we argued that he should have known about the ice, but he created the dangerous condition of the crappy handrail because he used those fence posts, like those that you drive into the ground. Yeah. Those are only meant to be temporary. And he put the thing up 5 years earlier. And he said once in a while he would have to go over there and bang it in. So, but that was an example of how they created the dangerous condition.
So the handrail was like a big fence post that he.
It was. That's what I said. I said this is not a handrail. This is just a temporary fence.
And your hand doesn't really fit on that. It's not.
It was also crappy wood. Code. And the other lawyer was blaming the elderly woman for not holding on to the rail as she's walking. But she said that she put her cane from her right hand, which is her dominant hand, to her left lane. And so the defense lawyer said, well, why didn't you just hold on to the rail? And she said, because it gives you splinters, and I didn't want splinters. So it was great. It was good. So falls are statistically the most likely thing to happen to us other than being in a car accident, right? Yeah. It's because, when you walk, we all know you could trip over your own feet. There's no liability there. But otherwise, you're typically tripping over something that shouldn't be there, right? And in our everyday life, there are distractions. It's hard to always be vigilant. And so you fall. And that's why we handle so many cases is because that involve falls anyway, because that's what happens to people. They fall. And we take a lot of grief, I think, as personal injury lawyers about fall down cases, especially those that occur in parking lots and sidewalks. But you and I both know that some of these falls alter the course of people's lives. I mean, they have to undergo surgery. They have permanent surgical hardware. They miss time from work. And again, if an elderly person falls, takes a major trauma like a broken bone, that shaves years off their lives, and that's not fair. And I think, I think it's important for the public to know is that we're not out there looking for these cases. As humans, we don't want people to fall and get hurt. But we also don't hesitate to hold property owners accountable when they fail to do even basic things to protect their friends, their neighbors, and their customers. Most of the defendants in our personal injury cases involving falls are people trying to make money, right? It's landlords. That's a commercial enterprise. It's big box stores. It's healthcare practices, all places that owe a duty to the public to keep their properties safe. I just wanted to say that piece.
Yeah. I mean, if the money's rolling in, you have to keep your property maintained.
Yeah. I mean, I remember a case you had, I don't remember specifically, but it was a fall, and the store, I think, had opened for business, but then they defended on that there was a storm in progress, or maybe you gave me this argument to use in one of my cases because I have one like this. The store opens, right? They claim there's a storm in progress, and I know that's slip and fall, but then they say, hey, we shouldn't be held accountable because there was a storm in progress. And it's like, you opened the doors for business. You wanted to make money, so you can't, it doesn't go both ways. You can't have your cake and eat it too.
Yeah, and it was inside the store the person fell anyway. It wasn't like they fell out far out in the parking lot.
Right. You're tracking in the water.
They're inside. Yeah, they're inside the store, and no one apparently mopped the floor or put rugs out or anything.
Yep.
So,
all right.
One other quick topic is lighting. to
Oh, yeah,
consider when
love
there's
that.
a fall.
Love that.
And if you fall in a store, typically it's well lit. But if you're outside in a heavily traveled area, whether it's a rental property or some parking lot that's just not properly lit, you could slip and fall or trip and fall due to something that you otherwise would have been able to avoid. But if you can't see it, then you're more likely to trip on it or slip on it, obviously.
Lighting is a favorite element of mine because I think, again, it helps you survive that motion for summary judgment because the defendant's attorneys never address it. It's hard to qualify. I mean, you can measure lighting through lumens and all that. And I had a trial where lighting was an issue, and I called in an engineer who I had paid to go to the scene to measure the lighting under the conditions that were present when my client fell, and it was a key issue in the trial, and we won. So lighting's big. I agree with you.
I had a case where the client went back the following day, the following evening, to take a picture. And at the time, it was like, I guess before cell phones, whatever, so they had an actual camera. And so when the picture was developed, it was just black.
Black, yeah.
So this is what I felt. This is what I saw. It was just solid black.
Yeah, it's weird with cameras, cell phones. I don't think that they take the right image, but that's good you had it. All right, well, I think that's it for our case in chief. Now we move to, is it legal? And Derek, how do you approach negotiations with insurance companies, and what factors contribute to a fair settlement?
Well, in falls, as in I say almost every case, first you have to assess liability, and you have to determine, is there really a solid basis to proceed with this case? Like, can I beat a summary judgment motion? Can I win at trial? And if those things are assessed to be in your favor, then you're fine. If you have weak liability, then you have to reduce the value of the case. And the value is premised on the injuries. So then we have to get the client's medical records, get all the records after the accident, go through the records, see what injuries were diagnosed, see how the incident impacted the client's life. Do they have out-of-pocket expenses, lost earnings, any other economic losses? And then these things are all kind of melded together and thrown into one pot, if you will. And how strong the case is, again, goes back to liability. Again, if you have strong liability, I would tell the adjuster we need a certain, a higher figure. And if we have weak liability, I'd be much more willing to compromise. If I feel like this is a case that's going to get thrown out on a summary judgment motion or a good chance of losing at trial, then I'm more inclined to settle for a lower number. But I also find that with adjusters, no matter how you assess liability, you don't tell them that up front, because they may assess this as being a good liability case, even if you don't see it that way, because you might know some details that your client gave you that the adjuster doesn't yet know. And so I go into every settlement negotiation, initially anyway, as if it's a good liability case, and start out rather high, and then I try to get a feel for what the adjuster is thinking and negotiate back and forth to get to a fair point to settle the case, if not better than fair. How do you keep your clients informed throughout the legal process, and how important is client communication to a successful personal injury case?
Client communication means everything to a successful personal injury case, and it means everything to the attorney-client relationship. I think that clients who feel as if their lawyer listened to them and understood their perspective of things after an accident will feel that they have had a good outcome, even if it doesn't mean there was a lot of money transacted. They just feel as if they had a real advocate and that the system or process worked for them. Client communication is something that I think is the leading reason why clients leave their lawyers. At Basch Keegan, we take over a lot of cases from other lawyers because clients are frustrated or upset. And the number one reason is lack of communication. It's not because they think their lawyer's doing a poor job. And so one thing that I do to ensure client communication is actually meet with the client. Typically, especially at the beginning of the relationship, when the injury profile is still evolving and the investigation is still underway, I will meet with my client every 30 days for the first 120 days. And it's pre-scheduled. So the client doesn't ever feel like he or she is too far away from me. The other thing I do is I try to put things in writing so that the client understands where we are and where we're going. And sometimes I do a better job than others, but especially in the beginning of the relationship, I put it in writing, and it's a roadmap. It's a roadmap for me. When I meet with the client the next time, I look at, hey, what did I just say to you when we were last together? We put it in writing, and we know what our goals and what our objectives are. I also think that client communication is critical for referring lawyers. When, a lot of the work we do comes from other lawyers, our clients come referred to us, and I think one way to keep a referring lawyer happy is to communicate with the referring lawyer, to let that lawyer know we're moving this case. We want a good outcome just as badly as you do and as badly as the client does, and we're trying everything in our power to do that. And I think that makes referring lawyers feel really comfortable, and they know that they're going to get their referral fee at the end, and that their client is being treated well. So I'm big on communication. Next segment, let's get local. So Derek, favorite bakery in Ulster County. I feel like this is a tough decision because the bakery world is evolving here in Ulster County. There's a lot going on if you want a pastry.
Yeah, there's a lot of really good bakeries around. It's tough to choose just one. I'm going to go with Meltaway Bakery in Saugerties.
Yeah, see, I don't even know what that is. Where's that one?
It's on 9W in Saugerties, just north of Berkeley Heights.
Meltaway, Meltaway left or right? If I'm driving
if you're going north, it's on the left.
Oh yes, I do know where you're at. It's a little thing, right? Yeah. So you think what do you get there if you're going?
Something different almost every time, but they have just really good pastries in general. They have this, I forgot what it's called, but it's a round, flat, it's like a Cinnabon, but it's round and fairly flat with cinnamon and sugar on it, the glazed sugar, whatever that's called.
Is this like a Saturday morning secret of yours, or do you do this on the way into the office? Because I never see you eating pastries. But
once in a while. I haven't been there very much, but every time I've gone there, I've always enjoyed their stuff.
This is a tough question for me because for my recent past, I'm so carb adverse. But I think that for bagels and hard rolls, I'll still do dicings. In terms of other baked goods, Kingston Bread has some good stuff.
Oh, yeah.
I like Village. I think Village has some interesting stuff. There's that little place out in Woodstock with Illy Coffee, and they do the little donut holes. What's that called? Cafe.
Yeah.
They have good little donut holes for the kiddos, if anybody's out there. I'll tell you, I did, is it the Half Moon Cafe down near the Strand in Kingston.
Yeah.
And my son and I found ourselves there one weekend morning recently, and we split a cinnamon roll, and it was delicious. I think it had cardamom in it or something like that. It was a little different, but it was very tasty. So yeah, I think there's a lot of good options in Ulster County. I don't really get out of Kingston much, so there's, if you went to other parts of the county, there's probably a lot of other good options.
And also the one in Ellenville, Cohen's Bakery.
Oh, that's great too.
I get there very often.
What is that stuff they do there? The rugula?
Yeah.
The chocolate rugula, that's very good. I'm trying to think of Rhinebeck. Does Rhinebeck have bakeries?
Sure
what is it called there? The one that's in Woods, they're all over the place.
Bread Alone?
Bread Alone. I mean, listen, they do a great product, Bread Alone.
Oh, yeah.
I think they do. I think that their stores are very nice, and their breads and pastries are very good. And they're an Ulster County-based company, if I'm not mistaken. So I think that they have to be given a lot of credit. They've done a great job overall.
Yeah, their first one opened up a long time ago, probably almost 30 years ago, up on Route 28 toward Boyceville.
And then they recently redid that too.
Yeah,
now
really
they have
nice.
a big outdoor section.
Yeah,
they do good work. I like their stuff too. In Rhinebeck, actually, if I'm in Rhinebeck, I usually find my way to Bread Alone. So, all right, well, that's it for Let's Get Local, and I think that's it for today's episode. It's time for closing arguments. Derek, I think you did a great job today, counselor.
Thanks. You too. Time to wrap it up. We hope you found this interesting and helpful. Hope to see you next time.
If you enjoyed this episode, please like the video and consider subscribing to our show. You can also catch us on Apple and Spotify. Thank you.